Now, Beaver had no real background in international humanitarian law or any apparent expertise in the Geneva Conventions or the law of interrogations. It seemed to me, on the basis of the conversations I had with her, that she'd never previously given advice on these kinds of issues, and that she'd been brought to Guantanamo from the torts section of the Pentagon. Yet it was she who was asked to sign off on this most important of decisions, the use of new techniques of interrogation. She described to me the circumstances in which she wrote her legal advice. No doubt the story she's given me is a partial story, and no doubt more will come out, and indeed some has come out in some of the hearings that have taken place, which tends to undermine some of the things that she said to me. Yet the essence of her story, I think, holds true, and it was significant. It indicated, on her account, that she was first told to provide advice verbally, sign off orally. If that had happened, there would have been no paper trail. She described to me the circumstances in which she decided, in order to protect herself, in the expectation, reasonable in my view, that any written legal advice she wrote would be subject to higher level review, to insist on putting her legal advice in writing. Her game plan, as she put it to me, was to get her advice up the chain of command, recognizing her own limitations, rather honestly, I thought, in the hope that in the military legal structure, someone higher up would eventually express a more informed and knowledgeable or experienced view. As Beaver was writing her legal memo, she was given just 4 days to do it, she tried to get help on her account from the General Counsel of the Joint Chiefs of Staff, from the lawyer at US Southern Command in Miami, from the Military Lawyers Training School, and from various other lawyers. And on her account, no one seemed willing to assist. And also on her account, she said she was stuck with the presidential decision on the Geneva Conventions. As she described, when she went to the pages of the rule book on military interrogations, they were gone, because for Guantanamo, the pages had been torn out. Who was she? A low-level entry type of lawyer to second-guess the decision of the president to do away with Geneva in relation to these interrogations. That, she explained to me, would have been insubordination. And as she told me this story, I met with her on several occasions, I began to understand a little more clearly the particular circumstances of the difficulty in which she found herself, recognizing also that the legal advice would or should have gone up the chain of command to more senior lawyers who would eventually have an opportunity to review her work. Her advice is frankly awful. I thought it was awful when I first read it, and I still think it's awful today. But I understand the circumstances in which she felt compelled to write it and in which she found herself. As she described to me, they were getting information of a new intelligence spikes. They believed a new attack was coming. They considered that al-Qahtani, who until then had been interrogated unsuccessfully using the normal military techniques of interrogation through rapport building, had information that could help protect the United States. And I could understand all of that. But even more, I came to understand the real circumstances in which she wrote her advice when she described to me what had not, at the time I spoke with her, emerged into the public domain. Namely, the visit to Guantanamo Bay in late September 2002, just a few days before she wrote her legal advice, of the most senior lawyers in the administration. On her account, Mr. Haynes, Mr. Gonzalez, David Addington, who then was the General Counsel to the Vice President, came down to Guantanamo, accompanied by John Rizzo, became the acting General Counsel of the CIA. You've got here 3 or 4 of the most senior lawyers in the administration. President Bush's lawyer, Dick Cheney's lawyer, Donald Rumsfeld's lawyer. They fly down on an executive jet for a day on the 25th of September 2002, and the message they leave to Beaver and to Mike Dunleavy is, do what needs to be done. And they watch an interrogation. Put yourself in Diane Beaver's position for a moment. I tried to do that as I imagined the situation she was in. And I imagine, or try to imagine, the impression that is given when you are a lawyer of her limited experience and you receive a visit from these 3 gentlemen. Now, Beaver's story was essentially confirmed to me in my conversations with Dunleavy, who also described how he had been handpicked for the job by Rumsfeld and by Feith, how he'd been personally interviewed by Jim Haynes, and how his background in interrogation was essentially what cast him as the right person for the job. Aspects of both of their accounts were later confirmed to me when I met with General Hill, who was commander of the United States Southern Command, a man I thought to be extremely thoughtful, who was obviously troubled by the adoption of these new techniques of interrogation. And from him I learned more about the circumstances in which he had insisted that there be Department of Justice sign-off on these new techniques of interrogation. And I went through the list of techniques with him one by one. At some point I asked him whether he'd ever be comfortable with any of these techniques being used on any Americans. And he said emphatically, without pausing, no, absolutely not. So if they couldn't be used on Americans, I inquired, how is it that they could be used on others? That, he said, is a question you should put to General Myers, because it was up there in Washington that all of these decisions were taken. So I tracked down General Myers, Chairman of the Joint Chiefs of Staff from 2001 to 2005, to my view as a British outsider, non-military type, probably the most powerful military man in the world, apart from the President of the United States. And I met with him at Georgetown Law School. I thought him a genial and a decent man, but formed the impression that he had been somewhat out of his depth in the decision-making process. And I don't express any disrespect in using these words, which I've chosen carefully. Because from the conversation, what I discovered was that General Myers simply hadn't appreciated what had been decided in relation to the Geneva Conventions. He thought they had decided to apply the Geneva Conventions at Guantanamo Bay. He hadn't appreciated that the President's decision was to precisely the opposite effect. And he thought that all the new techniques approved for use on Al-Qahtani had come straight out of the United States Army Field Manual. So we went through the list of techniques one at a time. As we got to forced grooming, removal of clothing, use of dogs, he became visibly uncomfortable. I should speak with Jim Haynes, he said. Eventually I did.